we've been at this since March 6th. We adjourned it from March 6th to March 13th and March 13th to March 20th. The plaintiff's allegation was that through March, the rent was $4,362, $313.45. In court costs for a total of $4,675.45. We spent some time last week trying to get to that figure. As I've said, no one was under oath. Mr. Roberts was here. Mr. Roberts has plenty of experience in this area, but he didn't have experience in this case, and he was unwilling to make any final decisions because of that. So as Ms. Bauer indicated today, there are a number of issues regarding recertification times and that sort of thing. And there were issues about William having income. William isn't here, which is not helpful because he's one of the defendants here, and he is also one of the sources of income. Ms. Cleveland, would you raise your right hand? Oh, I just did that. I swore you both. And as Mr. Popovitz indicated, the defendant was in the process of trying to vacate, which makes the dollar amount less crucial if we don't enter a money judgment. Let's say, like say you owe $1 million in rent, or you have to move out. And you move because you're not going to pay $1 million in rent. I didn't make a finding that you owed $1 million. We would have a hearing. Let's make it more realistic, $10,000. We'd have a hearing at some point regarding how much money you did owe. This is set for both of those things. And so Mr. Roberts, I think, was reluctant to enter into any sort of agreement. So let me ask this, Ms. Cleveland, you're in the process of moving your stuff. Have you found anywhere to move to?
No, I've tried, and I've called everywhere that every resource, every department. There are some.
That's why, Judge, that's why this matters more than just a possession judgment, because when she applies for additional housing, the first thing they're going to do is ask for references. That reference is going to be the prior landlord, who's going to then have to speak to the status of the account. So even if she consents to a possession judgment, that still dooms her ability to get future housing, even if there's no eviction judgment on her record.
All right.
From
your perspective, how much do you believe the rent is?
It appears to me that the rent should have been $224 for the first from June until this apparent recertification effort for $212. Based on documents provided by my client and the same document provided by the plaintiff, there is a form, it's a rural development form 3560-8. It's a summary of the tenant's recertification. In that form, the tenants are indicated at the income level of very low income, which is the highest priority by federal statute for receiving rental assistance. And yet, on the second page of that summary certification, they don't follow the process flow correctly. If the tenant receives rental assistance, enter line 28 on line 31 below. That box is checked, but then line 28 is not entered on the line below. The reason for that does involve Keystone, or apparently involves the presence or involvement of Keystone Place. But at no point in time were the tenants...
Well, I didn't ask you all this yet. Okay, I just asked you how much you believe she owes.
Explain.
So you believe $212 from June?
224, Your Honor.
All right. From June to
Arguably the present, if there's not been a new certification, but it seems that there was a rental adjustment. There was nothing in the records I received, but that was elicited at the last hearing, that there was a gross rent change in December, or something like that, so that would change the rental rate. And then there was this attempt in December, starting in January,
All right, I'm just trying to figure out how far apart we are. So 212 from, 224 from June to when?
at least December.
All right, so that's 6 months. 224 times 6 is 1,344. 224 June to December, 6 months equals 1,344. All right, then if we go forward from December to January, February, and March, what do you contend the rent is for those periods of time?
Based on representations from my client, $212. Absent any change in documentation, it would still be $224.
All right, so 224. All right. 224 times 3 is 672.
And that doesn't account for any payments that have been made.
2016. So do you contend payments were made?
Keystone Place paid $1,083 a month for 6 months,
After June?
Yes,
starting in June.
I can break Your Honor, just looking at the ledger, I can give you the payments
All right.
that are reflected in the ledger, so they're not contested.
All right.
All right,
Payments were what?
so payments, so here I'll go through this. Payments since June 1st are $1,083 on June 10th. $975 on June 10th. $34 on July 1st. And then also on July 1st, $1,083. And then there are 4 other payments of $1,083 that were made on August 1st, September 1st, October 6th, and November 10th.
All right, so during the period defendant contains the rent is 212. Someone other than the defendant is paying $1,083, give or take, all the way through November.
Correct.
All right, so 10/6, 1053. 1053 times 1, 2, 3, 4, 5, 6. $6,318 plus 975 plus 34, 1009.
So, Your
Just a
Honor,
minute. Just a minute.
sorry.
All right, 7,327. All right, so that would pay the rent through November. So what appears to be at issue from Enchanted Glen's position is the rent is December, January, February, and March, I think is what we calculated last time.
Yes, I can give you that total.
All right.
That is $4,372 based
I thought
on,
we had 4,362.
well, there's been a $10 late fee that must have been in there
All
that
right,
maybe wasn't it should have been last week too, but it hits on the 11th. We should have been here, but so yeah, and that's at 1,083 for December, January, February, and March with $10 late fees. The account is, I mean, just to clarify, the account is based on the ledger that I just sent Ms. Bauer as well. The updated there, it's current through November, so there's a zero balance as of November 10th. And then the balance forward for those months that you've identified is $4,372 and through March 11th or through today.
all right. So the fundamental disagreement is defendant claims rent is 224 and plaintiff claims the rent is 1,083. And the rub happened, according to Miss Cleveland, they thought Keystone was going to pay the rent for 18 months and Keystone stopped paying the rent as of December 1st.
The other option, or the other part of this though, Judge, is that the defendants would have accepted the rental assistance in the permanent subsidized housing had that been properly communicated. So the idea of the rapid rehousing program is to get people established into stable housing. These tenants were eligible for rental assistance and should have been put on that program from the jump.
All right, so who failed to do that?
At this point, I would say that falls on the property manager. If I may share my screen, I'd like to demonstrate where I'm getting this from. I'm not just making this up, I guess.
All right, go ahead.
I have redacted the personal identifying information from these documents, Your Honor. So this document here is the form 3560-8 that I referenced. It is, can you see my cursor or no?
Yes.
Okay, so it is indicated to be the initial certification for move-in. You see the tenants are listed as household members. The calculations here, what I was referencing, if the tenant receives rental assistance, enter line 28 on line 31 below. You see this box is checked. And I have to move you guys out of the way here. I apologize, this does have my notes on it, but if rental assistance, if tenant receives rental assistance, enter line 28 on line 31 below. So line 28 here is 326. Line 31, you see that that number is not entered here. 326 is not entered. There's a deduction for the utility allowance, which gets us to the 1,083. Where this matters is because up here, the current eligibility income level is V, and V stands for very low income. And that is the first priority under the rural development regulations for rental assistance. These properties have a rental assistance tenant selection plan. And Keystone shouldn't be paying $1,083 when these tenants are eligible for rent and able to pay $224. And that rent, that
Well,
assistance can
who
go up.
made that calculation? Is that your handwriting?
That's why I say I apologize that I wrote on here. That's me.
All right, but so where do we get that figure?
So if you follow how the form is supposed to be filled out, if tenant receives rental assistance, they're very low income, they're eligible for rental assistance. Enter line 28 on line 31 below. Line 28 is right here. And line 28 is 326. So the number that should have gone on this line is 326. But instead, the number that went on this line is 1,185, which gets us to the final NTC, that's net tenant contribution, also known as tenant rent, essentially, the tenant portion of rent. So here, they've determined that the tenant rent is 1,083. That matches what we see on the ledger. The problem is, this form is filled out wrong.
All right,
1,100
well, at this
is
point,
wrong.
you're testifying as a expert, or guess, as to what should have been done. I'm not saying you're wrong, but, and I'm sorry, Ms. Shaw, I called you Ms. Snow. What's your response to or their contention that the form, would you scroll back up a little bit, Meg?
Yep.
Wasn't down a little more. A little more, all right, little right there. All right, we got part 6 and part 7 and part 8. So according to this, rent is $1,083, which is what was charged, and Keystone was paying it. Their contention is that this wasn't calculated correctly. What's your response to Ms. Bauer's representations that she just made regarding how it should have been done?
Your Honor, to begin with, Keystone will not help people that get rental assistance. They pay the whole amount of rent. So if I was to have given them rental assistance, Keystone will not pay it.
Correct.
So at the time.
So if someone has a subsidized rental rate, Keystone won't pay it because there's an assumption that they're already receiving enough assistance, and Keystone pays rent for people that are not subsidized. Is that correct?
Correct. And
Okay.
once I get this information, I send their packet to our compliance department and corporate. They fill this out. They send this, they put this in the computer, and I print it out. I don't know what their rent is until after the fact, until I get it on my end. And that's what Keystone, that's why their rent was 1,083. In January.
And Keystone paid that for
Yes.
months.
Yes, yes.
And then at some point, Keystone stopped paying the rent?
They stopped paying the rent. I do believe, if I remember correctly, was been December 1st. Was their,
All
or
right.
November
What-
1st was the
what-
last rental payment from Keystone.
All right. So once that happened, should the defendants have had a recertification?
Yes, they should have. And they started to come over and they filled out the application portion of it, signed all the application part of it, but they never came over and finalized it by signing their lease, their current lease that they would have had after signing the application. In
All
January.
right, there was some discussion of that. Now,
Yes.
And Judge,
okay,
I don't have any of that.
I'm not allowed to send that completed because I was talking to my boss and they said, do not send anything that is not completed.
okay. So they don't get to double dip. They don't get a subsidy and then Keystone pays that subsidized rent. It's either all or nothing. So Keystone, and Miss Cleveland's representation is they said they were going to pay for 18 months, but at some point they stopped paying. So Mr. Popovitz is correct. The rent is paid through November. So we're talking about December, January, February, and March. Ms. Bauer calculated at $224 per month. Your testimony is different. The bigger question is whether they should have been recertified, not whether the rent should have been $224 per month. because it was 1,083 through November.
Except, Judge,
Uh,
I don't have anything, I have documents between, I have manager Kim Shaw, and I have a representative from Keystone signing documents that the tenants are being placed in this program, but I don't have anything showing that the tenants have consented to this or were given an opportunity to get on the rental assistance, the permanent rental assistance program that they were eligible for and trying to get into. That,
well, that's what we're trying to determine.
I mean, back in
Um,
June, I mean, not
But
getting,
what do they care? They got $1,083 worth of rent and they didn't lose a penny. Keystone may have been out 1,083 if rent should have been something different. But if their rent, they're better off with, if it was subsidized, they would have had to pay that rent
there's
from
two-
June, July, August, September, and October and November, and they paid zero.
yeah, and
Keystone
that,
paid it all.
Judge, there's two reasons. One is dignity. Like, a lot of people think that subsidized tenants ride and abuse the system, but actually a lot of my clients prefer to have the dignity of paying their own rent. Second of all, and I'm sorry, Judge, second, Keystone is a temporary program intended to transition people into stable housing. The golden goose is to get rental assistance. That is the goal that tenants have when they move into subsidized housing. So they do care, because if they were on that program, we wouldn't have had this sudden pulling out from under them of the sheet, or pull it rug. I don't know where sheet came from.
Well, I don't think they have any damages, but dignity is hard to put a dollar figure on, and it wasn't done. And I don't know why, but we now know that the Keystone subsidy was expired or removed or canceled. The defendant's contention is they came in and thought they had recertified. Ms. Shaw's contention is they did not. So we need to figure out now right now, according to plaintiff, they did not complete the recertification process. Keystone stopped paying their rent, and they contend that they owe, why don't you give me my screen back? We got this random stuff scrolling on the screen. $4,772. If you're, now, I don't have a witness to tell me what the calculation should be. You calculated it, but you're the attorney. So even if I use your figure,
I could do this through an adverse witness from the property management company.
well, I'm not sure she could answer it that way, but
I don't think it's fair to spring these exhibits on Attorney Popovitz without him having a chance to discuss and see them. I've got a couple of other exhibits.
well, there are exhibits that are in his possession also, but what I'm trying to avoid is a 2-day trial on this. I have to be in Kalamazoo at noon, and I'm not gonna make it. I was hopeful you guys could get somewhere, and you're not anywhere. So we're fighting about the difference of about $2,000. The farther we get behind, the less likely is the defendant's gonna be able to pay the entire rent. Keystone's no longer paying the subsidy. Even if we do it at a subsidized rate, we'll be into April. It's gonna be about $3,000, give or take.
At the subsidized rate, Judge,
So,
it would be about 800.
well, I guess about $800. 224. That's your calculation. I don't know what it really is.
Right. You said
the-
at the subsidized rate. So I just,
Yeah, at that rate. So,
Yeah, it's 11/20, it goes through April. At the 224, or whatever that rate was, it'd be 5 months. Remember, we're talking December, January, February, March, and then April. We're not into April yet, but for purposes of any
Yes.
continuation, it's about 1120
Sure.
plus the court costs and the other amounts.
Yes. Well, if you'll agree to that, we can use that figure right now. But I don't know that you're in a.
Well, here's
position to
Your Honor, may I have a chance and I don't want to waste your time, and I know you have to travel. I don't want to.
I'm already not gonna make it, so go
I
ahead.
appreciate the way you're handling this, and I've been sitting here letting Ms. Bauer testify and argue and commingled, and that's fine. I respect her, and I think she has as good a handle on these forms from an adversarial standpoint and an advocacy standpoint as anybody. But I agree with Your Honor's take on, dignity aside and all these other things. These folks haven't been damaged. They had 1,083 paid for them from June till December or till November. And the issue of whether that was more than what should have been charged is between Keystone and the complex, if there's any issue there between them. And I don't know that there is. I have no knowledge as to that. And then quite frankly, my guess would be if really we wanted to unwind the ball of yarn, 1,083 goes back to Keystone, and then 224 is charged to Miss Cleveland, who's then another 6 months behind in rent added to the December through April. So that doesn't put her.
Yeah, they're worse off if we went in that
Right.
direction.
Right, they're worse off. Plus Keystone's not even a party to this, and I don't know how we articulate or even handle the lack of presence as to there's no claim for the return of the 1,083 or any claim from Keystone against the Miss Cleveland and Mr. Roush for the overpayment or against the complex. However, Keystone may preface that type of issue. If here's one concern, I don't know that these folks can even, and I'm not saying this disrespectfully, but I think that 224 for now 5 months plus the court costs, that's a significant amount of money, and they'd still probably likely need some assistance to come up with all of that. And there's third-party agencies that may help them. I'm not adverse.
The third-party agencies won't help them if it's a subsidized amount.
So
they're not going to be eligible for Keystone or DHS or the others. That's either money they're going to have to pay. So if you agree to that number, we can use that. But I'm not sure at this point you wish to do that.
I'm long-winded, and I apologize because I'm getting to that issue. I wasn't aware. I think some other counties, the DHS might help if there's subsidies, but I defer to you and Ms. Bauer in that regard as to this area. But I'm not adverse to having a private conversation with Ms. Shaw, talking this through and making a decision as to the 224 to avoid sort of this length and the cost associated with Ms. Bauer's dissection of these forms and sort of the argument as to, is the application indicative of a recertification, or because no lease was signed, it doesn't process.
I'm gonna open 2 breakout rooms. I'm gonna let you talk with your manager. I'll let Meg talk with.
May I
go ahead.
One last thought, just because it's pressing, and something for Your Honor to consider, plus Ms. Bauer. We don't have a completed recertification currently. So we from policy standards, whether Ms. Bauer believes that's correct or she wants to make accusations as to mishandling or anything else that she's likely to do, and it's kind of insinuated, we don't have a completed recertification form and lease. So if we agreed to those figures just for the purposes of this 10-day order to get possession and payment and to figure out the possession action as currently prefaced with the court, we have this issue starting in May as to what or maybe April if it was today, because we're not.
It would be April.
It's April. What's the rent? And we're going to still have it at 1,083. This is why I enjoy conversations off the record between hearings with Ms. Bauer, because we try to work a global resolution that avoids those sort of secular arguments that continue to kind of reform every cycle. So I'll talk to Ms. Shaw and I'll get some feedback from her and we'll come back. But I wanted to put that out there that, equitably, it's not within the court's power to force the recertification at this point based on the preface of the pleadings in front of it. But if there was any tolerance for this amount just to be done with this, I won't say anything crass, but these arguments as to the amount and what amount it is and whether or not it's a relevant point, we've got to address that as well, both with Ms. Shaw, but then also with these tenants.
All right. I'll put you, it's not your fault. I'm missing a luncheon program and the afternoon program, but we'll get there when we get there. They're gonna start without me. All right,
While you're putting those rooms together, I just want to point out that this speaks exactly to the bias that my clients often face, which is that this whole conversation, the presumption has been that my clients can't afford $1,000 to keep their housing, and that they will be requiring public assistance, and that's just not always the case. Also, the damages that my clients are experiencing are this massive risk of homelessness that so it's more complicated. It's always.
it's always more complicated, but in point of fact, no rent has been paid since December. Enchanted Glen has a waiting list of people that are homeless that would like to rent this apartment.
Which these guys
Um,
again.
So there are always multiple sides to every story. I don't know if we're gonna accomplish much here, but I'm willing to give it a shot. I'll get there about 3 o'clock. Let's see what we got. Add a room. All right, assign room 1.
Gary, before you go in there, I still don't
Understood.
know what my clients actually would need to provide your client to complete this recertification. I've looked at the correspondence I've received, but there's nothing in writing about what they still need to do. So
Kim, you're sworn in. Thanks, Meg. Kim, you're sworn in. Why don't you just articulate without giving more than you're comfortable, but share with Meg what these folks would need to do to complete the recertification.
They would have to reapply because their paperwork is more than 90 days. And compliance department won't take anything over 90 days. So they would have to refill out their application and give me all their income, all their banking information from both parties, him and her.
Okay, all right, fair enough. Thank you.
Yep.
don't understand what was missing before then, but you and I can talk about that later, Gary.
Well, and I guess, Meg, remember, they didn't sign the lease. There's policies, and I understand your take, and I understand your equitable arguments that you're making, and you're a heck of an advocate for these folks, or all of them that come through. But if they don't sign the lease and they don't complete the process pursuant to the policies, listen, I'm not here evicting every tenant in Enchanted Glen. I'm here evicting certain ones that don't comply with the process. And so if they didn't sign the lease, we're not picking.
I wasn't trying to reopen the debate. I was just trying to let you know the things that I was looking for while you're talking to your client.
All right, okay, Mr. Popovitz, I'll put you in there with Ms. Shaw.
Thank you.
And then room 2, I will assign Meg Bauer and Mary Cleveland. Miss Cleveland, hit the button that says join. Mr. Popovitz, you had an opportunity to talk to your manager, Ms. Shaw. What's the plaintiff's position?
Your Honor, we've talked. I have a amount of respect for Miss Bauer, but I have a admitted lack of, I think, patience in some respects for these arguments when a non-payment turns into a complete breakdown or analysis of the recertification. And I've made my peace with that in the earlier comments that we're not evicting every person. So there's not a failure in the process, but some people haven't complied, and then there's consequences or ramifications. That being said, I had a wonderful conversation with Ms. Shaw. She understands. Her and I both work for higher ups in management at TM, but we're both comfortable putting this on the record. I would agree to resolve this with agreeing to the 224 rent due from December, January, February, March, and April. And I'd give them until the last day of April to pay that amount and have a full recertification process completed and accepted by TM or by Enchanted Glen. And I do that because I find that tenants who put themselves in these situations can benefit from not only the advocacy of legal services, but the assistance of legal services to help with the recertification process. Ms. Shaw, whether Ms. Bauer likes to like the answer or not, says that everything needs to be resubmitted because it's 90 days past due. We do answer to these subsidies. We have certain things that have to be done in accordance with the timelines and the current you know, the documentation has to be current. So where we would want is the last day of the month is April 30th. It's a Thursday. By then, they've paid all of this rent at $224 per month, plus the court costs, and they fully recertified, and we can move on. And I will deal with the internal communications to TM as to why they're only getting $224 a month versus $1,083 a month as to these months in question. There cannot be today or any day in this court case, based on the filings and the pleadings as currently situated, a determination of the recertified rent amount. It may not be $224 as Ms. Bauer has calculated because the information has to be resubmitted. But this is her opportunity, and she can certainly utilize my openness to communication throughout the recertification process to address any concerns she has with TM's corporate compliance as to the calculations, or help her clients to make sure that current documentation and appropriate documentation is presented so they get the most subsidy that they can possibly get. It'd be a global resolution, and one way or the other. And if they're not able to comply and they don't like the rent after that, everybody's still bound by leases and Michigan law. But this is an opportunity to not spend any more time in court testifying over rental subsidies, assistance, what should have been done, what shouldn't have. This is a non-payment case, and conceding the rent for those months and giving them the buffer of April to complete everything, moving forward with, by then, a well-informed decision as to what May's rent would be, seems like an appropriate opportunity, and it does save somebody from becoming homeless without having their day in court. I apologize for going on and for any tone that I may have taken, but this is the opportunity that I think presents itself based on the openness of these discussions and what we're willing to do going forward.
All right, Ms. Bauer, what's your position regarding that?
I think that that's generally a very fair and reasonable offer. I did, as we were being pulled in here, send a different offer to Attorney Popovitz. He may not have had a chance to see it or not, and he may not agree with it. I think it's a fair and reasonable offer if his client is willing to make the adjustment to the final account to reflect those numbers, and so that if there's no going backwards and undoing, that it's not just for purposes of possession. I think it's a very fair offer.
All right. Now, then they're gonna have to get recertified during April and late March. But
Which
it is very generous because it goes all through the month of April. So I find 5 times 224 is 1,120. We previously determined that court costs are $313.45. That leaves us with 1,433.45 due by April 30th.
But of course, Judge, I don't know. I guess I had sort of put a condition on that. I don't know if about the account actually being changed to reflect.
Well, I don't. What's your response to that?
Can that be explained to me? What are we looking at?
No, I don't need it. This is my ruling. I'm gonna accept your generous offer. If it comes to a money damage hearing and they're gonna claim that 1,083 is due and owing, in the unlikely event, we'll determine it at that time.
Well,
Ms.
I mean,
Cleveland, you've
there is
got until the end of April to pay $1,120 in rent and $313.45 in court costs, which is $1,433.45. You also need to go in and complete the recertification process. I don't know what your rent would be. There was an allegation that Mr. Roach had some income, and he needs to be here. He's sleepwalking through this. You're here, your lawyer's here. He's not here. He's a party to this, and his income is relevant. Now, he may have some illness and some other things I don't know about, but he does have Social Security, perhaps other income, a pension or something that will need to be calculated into this. But I find that you have 10 days to appeal this, Mr. Popovitz, which would still be the March 30th date. The rent due date is April 30, 2026. The rent is $1,120 and the court costs are $313.45. So the defendant now has 40 days, March and April, to pay the rent and get recertified or move out. You may decide you want to use that $1,400 to move into another place.
That's why I was
And-
asking the account question, Judge.
Well, they're not suing for money damage.
They
She's
did
paid
sue
the
for money
rent.
damages, Judge.
This is not a money damage hearing. This is a possession hearing. So if they pay the rent, they get to stay. If they move and we have a hearing regarding money damages, in that unlikely event, we'll determine it at that time. So essentially, Ms. Cleveland, you got what you asked for. Ms. Bauer has vigorously argued that your rent should be reduced to $224 once the subsidy ran out, and the plaintiff has agreed to that. The court costs will be the same no matter what. Now, my belief is if this is a subsidized rent, that you're not going to be able to get assistance from Neighborhood Inc. or Keystone. You can request it. You'll get a copy of this judgment, but I don't think if it's subsidized, they're going to additionally pay it. But I may be wrong on that, and different agencies may have different standards. I know Neighborhood Inc. doesn't pay for subsidized rents. So I don't know if you've got $1,433 that will pay your rent. That would be great. May 1st, the rent is going to be something different. You'll have to sign a lease. You'll have to agree after the recertification process what your rent is. If you're eligible for a subsidy or if you're not, as of May 1st, it will be different. If you pay this, then May 1st will start fresh. If you don't, you're subject to being evicted on or after April 30th. You can certainly discuss this further with Ms. Bauer. You and Mr. Roach are going to need to get in with all of your documentation and start the process to be certified to stay at Enchanted Glen under a subsidized rent. And your lawyers both spoke to this. If you get evicted, it's going to make it difficult for you to get in anywhere else. But the plaintiff has folded their tent and given you what you asked for. But at some point, you got to pay some rent. No rent has been paid in the last 4 months, and the 5th month is coming up. So hopefully between you and Mr. Roche and your sources of income, you can pay that. But it's incumbent upon you to get with management and get a recertification. Mr. Popovitz, I'd ask you to email me a judgment in that amount, $1,120 rent through April 30th, court costs of $313.45 for total possession only judgment of $1,433.45. The appeal date is still March 20th.
And I will put the payment due date by April, the last day of the month of April. And I don't know that the further order section has to articulate any specifics as to the recertification, but I think that's well established that this isn't a concession moving forward. It's an economic concession to solve this problem. And
Yes.
certainly they behoove themselves to complete the recertification process. They don't like to pay me to be involved in the recertification process, and I understand that, but I am offering my very affordable and economic assistance in the sense that if Ms. Bauer likes to reach out to me or needs to reach out to me to assist these people, I will act as a go-between and not become a problem for either my client or them in the sense of helping with the relay of information. I would like to see a global resolution here. And I appreciate your Honor's take and handling of the matter. And I appreciate Ms. Bauer's assistance and advocacy. And I remain open to communications to help her if she has any questions as she helps these folks through the recertification process.
Now, Ms. Cleveland, you've already started moving your stuff out of there. If you just
Yeah,
decide
got-
with Mr. Roach, you're just gonna move before April 30th. If you just decide you're gonna move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving out. I'm not determining how much money is due at this point. So if there is a hearing regarding money damages, that'll be at a different time and place. All I'm telling you is if you pay this amount, $224 for 5 months plus court costs, you get to stay there. Rent will be calculated at a different amount for May. All right, I appreciate everybody's effort in this. Meg, do you want to talk for, well, I'm going to shut everything down.
Yeah, I'll
So
call her.
if you need to call your lawyer, you can call her.
We'll discuss what is in your strategically the best interest in light of this
All right.
the judge's
All
decision.
right, thank you all.
Thank you, Your Honor. Take care.
Thank you,
Thank you,
Renner.
Ken. Take care, Meg.
Thank you.
Thank you, Ms. Cleveland.
Thank you.